state and defense all right to call that matter?
Yes.
All right, we will go on the record then. This is CR 2025-232, State of Arizona versus Richard Baptiste and Anisha Woods. Miss Woods is present in custody. With counsel, Mr. Lee. Mr. Baptiste is also present in custody. With counsel, Mr. Hamblin. We have present on behalf of the state, Miss Collins on our Zoom call, as well as Miss Green from the county attorney's office here in the courtroom. We have present Miss Clace, counsel for victims in this matter. This is a date and time set for a case management conference, scheduling conference. I will turn, if it works, first to Miss Collins, if we could, basically just an update on the status of ongoing issues related to disclosure. Any updates you can provide to the court there, as well as looking forward, what you believe would be most beneficial for setting on behalf of the parties.
Thank you, Judge. From the state's perspective, we were able to get the report out a few months ago, the OME report, which was really what we were waiting on. There may be some other disclosure that's sort of additional stuff that I'm not aware of, other than pieces that have been continuing to come in. We were waiting on some video that came from like trail cams, for instance, but they weren't even sure if we'd be able to download those. So other than something like that, Judge, all other disclosure, police reports, and such, audio, video, anything like that has been disclosed from the state's perspective. I also spoke with Miss Green, who I believe spoke with defense attorneys, both of them, I think, prior to today. There was an informal plea offer made to Mr. Baptiste. The state also informed Mr. Lee about that. There has been no plea offer to Miss Woods, nor will there be a plea offer to Miss Woods. Again, Miss Green has spoken with defense counsel in terms of timing, but I think the next thing we're ready to do is set the trial again, Judge.
All right.
And Judge, to clarify, I spoke with Mr. Hamblin and sent an email to Mr. Lee.
All right. Thank you. Miss Green, is there anything that you need to address before I turn to defense counsel?
No, Judge, other than I think we're at the point that we really need to set a trial date. Ms. Collins' calendar for trials is insane, but we're still looking out probably to 8 months away. We had been talking about late April, early May with Mr. Hamblin, and I think that gives plenty of time to hire whatever experts and things like that.
All right. Thank you. Mr. Hammond, I will turn to you. Anything additional, different, otherwise that you need to address with the court today?
Judge, we did get the autopsy report. I think disclosure is pretty well complete. I've had a difficult time getting a forensic pathologist because they seem to feel that they have conflicts just because they worked with somebody or knew somebody, or I don't know. It's different. And I'm finding out that all of them either worked for Maricopa or Pima County at one point or another. So I do have one this week, another one this week that looks promising. So hopefully we can do that. I would agree that April should work for a trial setting. I'd prefer not to do it during the summer months. So if we could set it for, I believe it was mid-April when Miss Collins would be available. I think that would work for us, mid-April to the end of May. But that's all I have.
All right. Thank you, Mr. Hamlin. Mr. Lee, same issues and any others that you need to address with the court today.
In the search also for forensic pathologist, we've got a name that I think, like you said, look promising. Maybe we'll follow up with that, but witness interviews are proceeding apace, Judge, and if the court was aware there was 108 witnesses or something like that. And so that's proceeding and we're getting reports as they come in. And I don't know what need to be done with respect to those later, but I don't anticipate anything else holding us up.
All right. And Mr. Lee, from your client's perspective, also ready and probably need to start talking about trial dates to get those issues ironed out right now.
Correct, and I heard the dates discussed, and I think that's, if the court can fit it in sometime, that time period would be great.
All right. Thank you. Ms. Clace,
And
Ms.
Judge,
Collins, go
before,
ahead first.
sorry, Judge, I did not mean to cut you off. I just, as before you go to Colleen, I'm looking at the first week that I would be available is April 19th. So sort of fitting it into what Mr. Hamlin said, that would be the last 2 weeks of April, and then basically the month of May if we continue to stay with the 6 weeks.
All right. Thank you for that note. I probably will have a little bit of follow-up with you on those dates specifically. Ms. Clace, anything additional separate that you need to address from your clients? And Ms. Clace, if you can hear me, I still show you as muted. All right. For whatever reason, I have not been able to hear any response from Ms. Clace. Ms. Collins, regarding the dates, I very much appreciate the parties discussing those. I am in agreement that ideally trying to wrap it up, begin it, of course, give it sufficient time, but also wrap it up before the summer months would be most effective for the court, I believe, helpful for potential jurors, etc. My question for you, Ms. Collins, is the conflicts that you have. I'm looking at starting at March 22nd. I think that's 3 weeks or perhaps 4 before the one you're proposing there. Are they other trial settings? Are they planned vacations just in general? What are the conflicts that you've got there?
I have a 2-week baby homicide that's just before this. And then the week that you're wanting to start, Judge, is the one time in the year for my last 10 years of my attorneyness, I take a vacation. But the main one is the first 2 weeks of April, Judge. I am in a baby homicide.
All right. And I don't want to necessarily get into those issues, but do you know, would that one take precedence over this based on time or status of defendants?
They are both also in custody, Judge, the co-defendants in that case. I think that one is older. I did not
All
look
right.
before the hearing, but I do believe that one is older and would take some precedence over this one, Judge.
All right. So hearing that from the parties, at a minimum, I think we'd like to lock down the times that we can and make sure those don't push any further out. I've heard from everyone except victims. I know that the state and Ms. Clace will follow up if there's any issues there. I am looking at that April 19th week as a beginning date. If we did that, we would have 6 full weeks prior to the end of May and the, I guess, Memorial Day holiday weekend. I know the parties have previously discussed, and I appreciate that very much, guesstimates as to timing. I think the original request was 8 weeks. I'm hopeful to narrow that and hopeful that the parties are able to narrow that with disclosure and everything being provided as we proceed forward. Things like witness lists being narrowed down to those who are, will be called by a party. My thought would be for now to set trial starting that week of April 19th. The first day of trial would actually be April the 20th. Again, we would plan to hold trial Tuesdays through Fridays, allowing the operations of the court to continue in other cases going forward. I would set aside the week of April 20th through the week of May the 28th at this point. Are there any issues or objections with those 6-week time periods right now from any of our parties?
No, Your Honor.
I don't believe
For
so.
your own.
My thought would be right now that we will schedule that trial date, get that on the court's calendar, on all the parties' calendars. Right now, I don't have any, set conflicts for the beginning of the month of June. If it became necessary, we of course could talk about those. The court, myself, as well as court staff would be mindful that originally the request was for some additional time there, and we would kind of play that by ear, take that as it may come. If any of the parties are very sure at some point, whether that's now or a month from now or 4 months from now, that we're going to need more time, I would ask that you just make the court aware of that by filing a motion or whatever needs to be done. The court will again send out a trial setting order with some of the deadlines tied to that. I won't go over all those on the record today. Do any of the parties, other than a final pretrial conference, which would be probably in the range of a sending out summons and for jurors, range of perhaps beginning or middle of March, and I could be wrong on my dates there. The jury people from the clerk's office, as well as my staff, are better at those. I'm thinking probably a final pretrial conference that we would stand or plan to have as a hearing date, where motions could be heard, arguments could be made, perhaps in the February timeline. Other than those that we will set by minute entry as soon as we're able to put that together, along with the trial dates, are there any other requests for dates and times that we believe any of the parties need?
Judge, I think perhaps we even set, if you're available, the February 22nd, which would be a Monday, if we just make that sort of a motions day. But additionally, at that point, if you're looking to reach out for the potential jurors, at that point, maybe we talk about the questionnaire, or the parties have finalized it by that point, and then can address a jury questionnaire with the court, which I think would take a little bit of time. But I have that week right now, or at least partial. So I potentially, if we set that and have it cleared for the most part with beyond your morning calendar or whatever else you have, Judge.
That might be a good idea. Ms. Collins, do you have other days that week, or is that day particular available?
I think that would be the best day available. That one is open right now, which is
All right. Because of our contract attorneys, 2 of which are here, and the state, I think I could block that out instead of doing law and motion calendar that day set. I would say at least either a morning or an afternoon at a minimum, and possibly consider the others. Are there any objections to that? I think getting that on paper probably is a good idea. February the 22nd, a Monday.
What time?
My thought would be to set it at 1:30 in the afternoon and set aside the whole afternoon until 5 if needed that date. Hear from the parties if we believe we might need more than that. All right. I don't see any objections to that. I think that's a good recommendation. So as part of the order, we'll also make it in the order, but I will be setting a final, not pretrial, but a preliminary prior to trial hearing date to hear motions in limine, anything that we can resolve prior to trial, probably to discuss voir dire questions, juror summons questions, questionnaire questions, all for Monday, February the 22nd at 1:30 p.m. I won't be scheduling a law and motion calendar for myself, at least that date. And so I think we should be ready to hit the ground running at 1:30. All of the parties do need to be present in person. Council can determine that if council intends to be, directly involved heavily in questioning or something like that. My strong preference is that they be in person that time of year, in addition to our regular problems. The internet is somewhat suspect, and we have had problems. I wouldn't want that to limit anyone's ability to present that date. We will, of course, add other deadlines and orders, probably a number of status conferences, maybe a couple of status conferences. I don't want to put too many months between a chance to just check in with the parties, make sure everything's progressing. So we'll add some of those. Mr. Lee, did you have a request?
And to deal with the motion for protective order before this date?
I have to remind myself, Mr. Lee, that was on behalf of the victim that was filed.
But yes, about keep the autopsy and the medical examiner report out of the public.
Right. Thank you. And I don't believe there were any objections noted to it. Am I correct as far as the parties go regarding that?
I don't think there's gonna be an objection,
correct.
Judge.
And Ms. Collins, Ms. Green, no objection from the state.
No, no objection.
All right. Because it may have non-parties weighing in on it, if they're allowed to, or if they attempt to, I did want to make sure that we gave at least the general response time. That looks like that is closing soon. My intention is, and I'll ask my JA to specifically follow up with me on that I will rule on that probably within the week. If there are any responses filed by parties, non-parties, that anyone would like to reply to, especially Ms. Clace, I will give time for that. If I don't receive any objections, I intend to rule on that probably by the close of this week, if I'm doing the math very correctly in my head regarding time limits. Thank you for that reminder. All right, Ms. Collins, is there anything additional that you believe we can address today?
I don't believe so. Ms.
All
Green?
right.
Nothing for me.
Thank you, Ms. Green. Ms. Clace, if you can hear me and if you're able to unmute and need to address anything with the court, I'd be glad to hear from you. If not, I'll just ask the state to follow up and make sure that victims, Ms. Clace, are advised regarding those issues. And if there were any difficulties, I apologize for that. Mr. Lee, anything additional from your client today? Mr. Hamblin?
No, Judge.
All right. The court does thank the parties for their presentation, especially their preparation and discussion of those issues prior to our hearing today. That makes it go much more efficiently. We will be adjourned. The court will be issuing that bench order addressing trial dates and additional dates. If there's issues or troubles regarding those, we can address those as needed.